Hello. In this section, I will be discussing current United States court cases and how they're related to education in America. Our first case is Houston Community College System versus Wilson. In 2015, Houston Community College school board member Sam Wilson was censured by his fellow board members for some malicious remarks he made regarding fellow board members in Houston Community College's board system as a whole. He was ultimately suspended from the board, and he sued the community college for violation of his First Amendment right to freedom of speech. The question at hand is, does the First Amendment restrict the authority of an elected body to issue a censure resolution in response to a member's speech? And the answer is no. The Supreme Court ruled in Houston Community College's favor, saying that as a teacher or a school administrator, you have to be very careful what you say. And he knew going into this that what he said could be taken poorly and could result in loss of his job. How does this relate to our course? Well, the relationship between school boards and school administration has a thin line to balance on in relation to private lives. On page 228 of our textbook, American Education, the 20th edition, by Joel Spring, Spring writes, "It would appear that the major concern of the courts is whether teachers' private lives interfere with their professional conduct as teachers. But the difficulty of establishing precise relationships between private actions and ability to teach allows for broad interpretation by different courts and school authorities. Teachers should be aware that there are no precise guidelines in this area." While Sam Wilson wasn't necessarily a teacher himself, it is important to note that as a board member, you do have to be careful what you say in your private life, as it can reflect on your career. Our next case is Kennedy v. Bremerton School District. In 2022, high school football coach Kennedy was suspended for preying on school grounds. Before and after football games, Coach Kennedy, who coached football at a public high school, would pray on the 50-yard line, as he was inspired by a movie he had once seen. On occasion, students would join and pray with him, although he never asked them to do so, and other schools would do it as well. However, the school district did not like this very much, as they thought that it might be seen as him pushing religion onto his students, and suspended him just to make sure that they wouldn't be violating the Establishment Clause. So the question is a public school employee's prayer during school sports activities protected speech? And if so, can the public school employer prohibit it to avoid violating the Establishment Clause? The Supreme Court said yes and no. Prayer is protected speech, but a public school employer cannot prohibit it to avoid violating the specific clause. Kennedy was kept on as a coach, since he was not encouraging the students to pray with him. The students were just doing it of their own accord. How does this relate to the course? Well, this case directly relates to the social goals of schooling. It provides some insight on whether or not public school teachers can publicly pray on their own. On page 33 of our textbook, Spring writes how the U.S. Department of Education issued guidelines for school prayer and religious instruction. These guidelines are very lengthy, but nowhere in there does it say that teachers may not pray on their own as long as they're not coercing other students. This case also overturned the Lemon Test, which ruled whether or not religious actions could be taken out of context in a school district. While there are many different court cases that are going on right now that directly affect education, these are just a few of them. Later on in this portfolio, you will learn more about current events in America and how they are related to our course. Thank you.